What is a bench bar meeting? Bench bar meetings are meetings involving the judge or judges of a particular court, such as criminal court, family court, or commercial court, and the lawyers who practice in that court. In criminal court, both the prosecutors and the defense lawyers would be invited to attend. The meetings are often informal and their discussions frank and spirited, but always mutually respectful. The purpose of these meetings is to discuss issues and problems of shared concern and interest, and to ultimately develop mutually agreeable solutions to the problems. There are no limitations on the subjects that might be discussed, but there's often a focus on day-to-day issues for court procedure and scheduling. Attendance is not mandatory but highly encouraged for lawyers, as it is an opportunity for them to express their problems and concerns. It must be emphasized that bench bar meetings take place in a collegial and friendly atmosphere and are intended for mutual problem solving. Judges and lawyers in Vermont have found that bench bar meetings provide an excellent way for improving the operations of the courts, for enhancing the administration of justice, and for developing mutual respect. How is the meeting conducted? Is the meeting an open discussion?
Bench bars are generally intended to be a relatively informal setting where the judge and the lawyers can have a dialogue. How each meeting is done probably depends a lot on the judge and their own personal style. Some meetings might be chaired by an attorney who might be doing a presentation on a particular topic, such as a change in the law for all of the lawyers. So they aren't all going to be the same.
I've learned, too, that it's important for a judge to first listen to what the attorneys have to say. First, I want to hear what their thoughts are on how we can better serve the public. But also, there's a danger if I was moderating the meeting of at least there being a perception that we are saying this is what's going to be talked about and only this. And I don't want to encourage that perception. I want it to be an open dialogue so that all attorneys present feel free to bring up a relevant topic.
The meetings are a collegial type of meeting where anyone can participate in the discussion, and we actually encourage as much collegial discussion as possible because you don't get to do that in the courtroom in the context of a particular case.
What prompts a bench bar meeting to take place?
The initiation for a bench bar meeting can come from lawyers or from judges. Several years ago, when our court's jurisdiction was expanded by the legislature, Judge Wright and I, there's two environmental judges, decided that it would be best to meet with lawyers for the purpose of explaining to them the new jurisdiction that we now had and how we wanted to proceed in environmental court hearings. So in one sense, it's the purpose of a bench bar meeting is to assist the court in making sure that the hearings themselves run well. If we don't have those kind of meetings, it would be more difficult to go through the explanation during the hearing and for lawyers to not know that beforehand in the course of their preparation. So we like to meet regularly with lawyers to explain to them, hey, we think this kind of process works in a hearing. What do you think? And to allow them to express concerns or suggestions that they have about how we conduct a hearing. Our goal is to conduct an evidentiary hearing in land use appeals as efficiently as we can and with the theory in mind that we're attempting to allow every party to have a full and fair opportunity to offer admissible, relevant evidence.
What should be accomplished? So what exactly is to be accomplished at a bench bar meeting? Here are some general ideas of the standard goals that a bench bar meeting will hope to achieve. Establish a structure to identify problems and formulate solutions. Establish communication between bench and bar and a level of comfort to effectuate common goals. Jointly facilitating innovation or change and anticipate and discuss areas of resistance or difficulty. Solving a specific problem if the committee is ad hoc to address one issue. improving the level of practice and behaviors in court for judges, attorneys, and litigants. Serving constituents, parties, victims, witnesses, jurors, the general public, the media, and other branches of government, other than participants, bench and bar. To actually help each other by exchanging ideas. Example, judges' top 5 suggestions for attorneys, and attorneys' top 5 suggestions for judges. To have fun. Bench bar meetings are intended to establish a professional yet informal setting facilitating in the discussion of these issues and topics of mutual interest and concern. Therefore, it can sometimes be beneficial to create an atmosphere where dialogue can flow more freely. This was a workers' compensation bench bar meeting. This is a state agency that handles workers who are injured on the job. 220 attorneys and 26 judges were in attendance. Who would be able to call such a meeting? Is it only a judge?
Well, again, this is slightly different because it is a meeting of the Bar Association Committee. So the committee chair decides to call the meeting, but although in practice it's usually at the end of the previous meeting, the group as a whole decides when we need to have another one. Certainly the judges can suggest it if there's a topic that needs to be addressed. But usually, since we know we're going to have one in September and one in March at the Bar Association meetings, it's a discussion of the committee to decide whether to hold it.
Who is usually invited to the meeting? What kind of participants can you expect to see at one of these meetings?
Well, it depends. In some courts, for example, in the court I was in before, we had an email database. It included people other than lawyers because in the juvenile court, there are guardians ad litem who are not lawyers, but who are volunteers who work in the court and speak on behalf of children. They would be invited to the meeting. In a family court setting like that, there's a broader group. It would also include, for example, people who worked for the child welfare organization for the state. So those people were part of our invitation list.
It's open. I hadn't thought of it this way, but our meetings are public meetings. The way we advertise the meetings that we have, including with specific committees or sections of the Vermont Bar Association, is certainly to advertise to all those committee members, but that the notice of the meeting also goes out to the Bar Association generally. So all licensed attorneys who are members of the Vermont Bar Association are aware of this meeting that we're having today. And your question reminds me of a topic that we were just addressing yesterday. Yesterday afternoon, I received an email from the law school from a professor saying, would you mind if several of our students attend and observe your meeting on Friday? We said, certainly. The vast majority of the people you'll see at the meeting are attorneys who are interested in how we practice in the environmental court hearings. They want to know how they can do it better, or they want to get an opportunity to offer their comments on how we can do it better.
What is your role in developing the content or agenda prior to these meetings?
Initially, what I've done is had either myself directly contacted the attorney who runs the local bar, or have the clerk's office contact him and suggest some dates that I would be available and let them decide what works for the bar to set up a time. And then in terms of my preparation, once a meeting is scheduled, it depends on whether there's a particular topic that is being addressed. But for example, for the meeting that we had today, I basically sat down and came up with an agenda of items that I thought would be useful for the bar, and then prepared some written materials to share with them.
Well, I primarily like to serve a role in preparation for those meetings of just assisting. In one sense, I want the attorneys in the first instance to be able to offer their opinions of what they think the topics are we should address. For example, we're going to have a meeting with the environmental law section of the Vermont Bar Association later today. In the course of preparing for that meeting, I emailed the chair of that environmental law section, Attorney Jerry Tarrant, and said, what do you think the agenda item should be? Now, Being a judge, I want to make sure that we have an agenda so that we keep on track to that. And knowing that both the attorneys and I have work to do later on, I want to make sure that we go through that agenda keeping the clock in mind. Give people a full and fair opportunity, but sometimes lawyers and judges can go on, so I want to keep to a specific agenda as well.
Ultimately, I develop the agenda, but clearly there are a lot of people that have input. The judges have input. The Bar Association has input. In this instance, it was the pro bono coordinator who asked me if she could participate. 9 months ago, she called me and said, you know, can we get on the agenda, and we'd like to participate with you because we have this idea. And I thought it was a good idea. The Attorney General's office came to me and said, we'd like to put on a conference. What do you think about that? And I said, yeah, I think that let's work together. Let's get the law school involved. We'll put that on the agenda for the bar meeting, the environmental section meeting, and we'll see if we're interested, if the membership's interested. And I didn't make that decision. I put it on the agenda, and then the membership voted on it and said, yeah, it's a good idea. Let's do it. And then I've been working with the Attorney General's office, but I draft up the agenda. I circulate it, ask for comments, ask for additions, and so everyone has input.